Good day to you and welcome to another Paddocks Club video tutorial. Today I'm going to deal with some transitional issues. As you know, the Sectional Title Schemes Management Act and the Community Scheme Ombudsman Service Act both came into operation on the 7th of October 2016, and on that date the prescribed management rules under the Sectional Titles Act were replaced with a new set of prescribed management rules under the Sectional Title Schemes Management Act. So, if you called a meeting before the 7th of October 2016, it was correct to do so as per the prescribed management rules that applied at that time. And that notice remains valid, even though from that date onwards, it would have had to be called differently. This means that those meetings have in fact been properly called, but they must now be held in terms of the prescribed management rules under the Sectional Title Schemes Management Act. And in some cases, I expect this will cause confusion. Already I've had questions about proxy forms sent out with a notice prior to the 7th of October. But that notice and the proxy form weren't substantially in the form of the new prescribed proxy form. My view is that if an old style form is used both for the proxy or for the notice, the chairman should allow it and allow the meeting to get on and do its business without it saying that it's now not as it is currently prescribed. Another important transitional issue is the registration of schemes with the Community Scheme Ombudsman Service. So all sectional title schemes, as well as of course of all other forms of community scheme, must register with the CSOS within 30 days from the 7th of October 2016. The CSOS registration form can be downloaded from CSOS.org.za. It's the CS1 form called Registration of Community Schemes, and it has 8 sections, 8 parts to it. Finally, let me talk about CSOS levies. These are payable quarterly in arrear from January 2017, so you must start collecting them from January next year, but you only have to pay them over in April. Best get ready for that. The levies are based on ordinary monthly contributions, so no CSOS levy is payable in respect of a particular owner if that person's contribution is under 500 Rand per month. But higher than that, it's 2% of the monthly levy to a maximum of 40 Rand per month, which actually equates to a levy of 2,500 Rand per month or more. The CSOS also has a requirement for Fidelity Insurance. If you haven't already got it, you must get insurance cover protecting the scheme against loss due to theft or fraud from various insurable people. Look at Regulation 15, which you'll find under the CSOS General Regulations under the Acts tab in the club. There you will see details of the insurable persons, who include trustees and managing agents and anyone else who could steal the scheme's money. If your managing agent already has cover that complies with the particular requirements of that Regulation 15, then you don't need to take out as a scheme more cover for that person. But the managing agent's insurer must note the scheme's interest in the managing agent's policy. The amount of cover that a scheme needs is the total of the scheme's reserves that they've got put away, plus a quarter of its administrative budget for the current financial year. Thank you for joining me in this video tutorial. If you have any questions, let's deal with them on the discussion forum.